What's up, you guys? Andre here with Pinnacle Credit Repair, and today we're going to discuss a very important topic, the federal debt collection laws that you should be aware of. In case you guys may or may not be aware, there's something called the FDCPA. I'll leave a link right here. You can check it out at consumerfinance.gov, and this is a federal law. A federal law protects you from debt collectors. So let me just give you a basic understanding of it, but I encourage you to do research here at consumerfinance.gov for more information on it and the exact laws on how they work. This video will be an easy to understand guide for you to understand how this works on the very basic level. So let's dive into it. So the Fair Debt Collections Practice Act, FDCPA, is a federal law that basically prohibits debt collectors from using false, misleading, or deceptive practices to collect debt. So to give you an example of something that's misleading, so if they're trying to collect a debt that is in fact non-collectible, such as a charge-off, this could be reported on your credit report like that. Another thing is if the amount that's owed is not verifiable, and they're trying to get you to pay for that debt where the balance is not correct. And there's been often times where there's tons of discrepancies in the balance of the debt that's trying to be collected from the debt collector. Another example would be if they demand that you pay and they send you to court. Well, the debt collector can't send you to court. It's the actual creditor. And so a very important thing is to understand this. The debt collector really has no legal rights to collect the debt unless it's actually a lawyer. Okay, these other, let me turn on the air conditioner here. Hold on, it's getting a little hot. And when it gets hot, I can't really talk good. So bear with me here. Okay, so yeah, the debt collector, isn't supposed to collect any debt from you, but often people can be misled into thinking they have to pay them. Often, if you have a call, well, here's one thing that came up and it's happened, where the debt collector calls you. First of all, they're not supposed to call you at certain times. We'll go into that. But if they call you or send you a letter and they are trying to get you for pay for deletion, if they're the ones actually doing it, that's also breaking that first, stipulation. Now these aren't the exact laws, but these are just an explanation and a understanding of them. But if you have to look at each section, you can refer to consumerfinance.gov. But this is basically the basic of these three premises: false, misleading, or deceptive. That's the criteria of the Fair Debt Collections Practice Act. Anything that they're doing is false or misleading or deceptive. To prove deception, it's an intention. You have to understand context, and it takes a really good consumer advocate, such as myself. It doesn't require a lawyer to do this. I mean, anything that you do in credit repair or debt collection, if you go to court, it requires a lawyer, right? I don't have to be a lawyer to understand this, and you don't either, because these are your consumer rights. Unless you're going to court, then you legally need to have a lawyer to represent you that's competent of the law and basically file motions and whatever it is that you're trying to do. But you don't have to be a lawyer to know this, and you shouldn't have to hire a lawyer to know this, especially if you're trying to fix your credit, because credit repair is a great defense for debt collection, because if you can find violations within the Fair Debt Collections Practice Act or any of your consumer rights, because the FDCPA is just one of your many consumer rights. There's a ton of them, right? So you have basis for suit or legal remedy or whatever it is against the damages. This stuff can adversely affect you, and if they do, you can prove damages and you can get some sort of settlement from them, right? Or get some compensation if you go the legal route. Or if you don't want to get money, you can get this stuff off your credit report, any debt that is violating this. they're sending you a letter that's misleading is a violation. If it's false, the amount that they're stating that you need to pay when it's charged off already, that's false. It's also false when the balances are not correct, which leads you to another thing, which is debt validation, which is really important. I've done debt validation for tons and tons of my clients and have used the the Fair Debt Collections Practice Act to help tons of my clients over the past decade, and it's very effective. So deceptive would be, I would say that would be lying, right? Like if they're actually lying about a debt that's not theirs, if they're stating that you need to pay them, that's deceptive. And also if they're calling you in any inconvenient time, that's also deceptive, right? To think that they can call you if they're using a different number, if they're not representing who they are. If they call you and you have a recording of it, right, and they're representing them as the actual creditor, they don't disclose that, that can be a way. There's a few ways that could work out in your favor. So another thing is restricting the Fair Debt Collections Practice Act restricts the times and places where collectors can contact consumers. Okay, so I would read up again on these specific times because there's rules for this, right? So they can't call you at any time that's inconvenient to you. They cannot call a family member. They cannot call your work. So if they did that to you, or even sent a letter to your business address, it's a business address, it's a professional address, not your home address. And if you're a sole proprietor, you know, but if you actually have a corporation, like a lot of my clients have corporations, S Corps, C Corps, they're not just a sole proprietor. They have a board, they have employees and stuff like that. And even employees that get that mail, and if it says there's a lawsuit or whatever here, it could be catastrophic. So they can't do that, right? Depending upon where they send it, they can't send it there. They can't send it to your work, can't send it to a family member. They just can't. They can't call a family member and do that. Okay, some people have even experienced catastrophic losses where they called a friend and the friend is like saying, hey man, I didn't know you owned this debt. Why are they calling me? And then the friendship goes sour, or that's just one example, or maybe an ex-girlfriend got the letter and then it blew things up. So it could be emotionally stressful and damaging. So that's important. Again, those are just some examples. I'm not going to leave all the examples here because we want to focus. Number 3, requiring debt collectors to provide written notice of the debt. Now this would lead to the whole validation of the debt because how it's written is important. So requiring collectors to provide written notice of the debt, including the amount owed and the name of the creditor. So again, you need to understand that. Who is the actual creditor? And you don't want to give debt collectors a one-up on you. So oftentimes in the credit repair process, and I talk about credit repair because this is not a debt settlement video. This is a Fair Debt Collections Practice Act video pertaining to credit repair. So that would be the theme. The theme is the Fair Debt Collections Practice Act of this video, but it's pertaining to credit repair because doing credit repair and then doing debt settlement are two different routes. However, credit repair is a good prerequisite for the debt settlement process, but it's the beginning process. And then there are times where credit reporting can in fact impact the debt settlement process in your favor if you know how to do it. And that, you know, alludes me to this whole thing where they have to disclose the amount owed and the name of the creditor. And so if you're seeing any of those changes, like on a credit report or on the letter that they sent you or on the phone, then there you have it. They're not following the rules, okay? They require collectors to provide written notice. And if they didn't provide you written notice, if you haven't got anything, only thing you got is calls. That's another thing. There needs to be written notice of this whole agreement. And actually, it goes to your privacy rights, which I can make a video based upon your privacy rights, because how information is transferred to an original creditor and a quote-unquote unauthorized third-party debt collector, whatever you want to call it, that whole process is under the scope of your privacy rights, which they vary from state to state, but they also vary from the federal level, which is the most important one. And so you can create a case upon that if your privacy rights have been violated. And That's a very important thing here. So credit repair, there's so many consumer rights that intertwine with other laws and rights and stuff like that. So you can't just focus on one law, and you just can't focus on one method. Just like Fair Debt Collection Practices Act, this would be something that you could deal directly with the creditor, right? You can communicate directly with them or not, right? The creditor, yes, but the debt collector, maybe not, right? So that's very important to understand. Number 4, providing consumers with the right to dispute and verify debt. So you have the right to dispute it. There's a whole process called debt validation. I have another video about that here, or here, somewhere around here. And you can validate, you can dispute these debts and validate. And a part of the rule of the Fair Debt Collection Practices Act is that once it's disputed, they have to halt collecting that debt. So that's a good strategy. So there are strategies and mechanisms you could use to postpone the actual collection of the debt from a legal perspective if it's gone to litigation. So, but we'll go into that later. So anyway, this is the basic of the Fair Debt Collection Practices Act. Now moving on to debt collection. So give me a moment and let me write it up here for you guys. Now for the whole debt collection process. We're going to do a very brief overview regarding this. So let's dive into it. Okay, so what is debt collection? Okay, so as you can see on the whiteboard here, debt collection is a process of pursuing debts owed by individuals or businesses. So if you have something written in your name that you owe a creditor, or in your business, there's ways they can collect that debt. So it typically involves a creditor, right, which is the original creditor that extended credit to you, extended some sort of asset, some loan or some sort like that to you. The party to whom the debt is owed, that's the creditor. And a debtor, the party who owes the debt, which is most likely you. All right. So there are types of debt. So we understand there's a creditor and debtor involved. The creditor is the one that's trying to collect unpaid debts, and then the debtor is the one that owes them. Okay. Now, the types of debt you could possibly owe. You guys probably have this already. The types of debt: credit card debt. Maxing out a credit card, defaulting on it, not paying it is a debt. Medical debt: had an emergency with your, like a car accident or a skiing accident or a motorcycle accident, you got hurt, or maybe you had some physical ailment like some sort of disease or something. I don't know. You got to pay that. You got to pay the hospital. If you don't, then you owe that debt. Student loans, unpaid student loans, or student loans that you have. Mortgage debt, okay. Personal loans and auto loans. Those are all basically the forms of debt which we all are aware of. Now, the role of debt collectors, okay, they're basically a third party hired by a creditor to collect unpaid debts. Now, whether they are legit or not is another story. Typically, from my understanding, if they're a lawyer, then they have the right to go after you. If they're not a lawyer, then they really don't. And so it goes to say that there needs to be a good consumer advocate to kind of unpack how that personal information from the creditor was given to the third party, and that verification process and that validation process will kind of mess them up. Okay, so there are provisions, key provisions underneath the FDCPA that you need to be aware of. Number 1 is prohibiting harassment, abuse, or intimidation. Some examples of that: harassing you, calling you before 8 a.m. and calling you after 9 p.m. That's a form of harassment. And typically, if they have the audacity to call you before 8 a.m. in your local time, and they intimidate you legally, sending you a letter as well. Okay, so that is a violation of the Fair Debt Collection Practices Act, and you should take a record of how many times they called you before this time and build your case. Then you could get damages later on. So they can't call you before 8 a.m. They can't call you after 9 p.m. unless you allow them to. And they can't call your work during working hours. If you told them not to, they shouldn't do that as well. So that's a violation as well. If you have a work phone number, like a business line, they can't call that line as well. So a lot of us, it's 2023, a lot of us are business owners. We have a business line on our phone. It's not our personal phone, but it's our business phone. So that's another thing. I use multiple apps with different, with different numbers. I have different businesses, but multiple numbers on one phone. So yeah, you could, that could apply to you. They can't call you at any time that's inconvenient for you. So that is number one, intimidation. What are some examples of intimidation? Restricting. So some examples of prohibiting harassment, abuse, and intimidation is they intimidate you legally to take you to court. That's legal intimidation. That's against the FDCPA. If they say they're going to seize your property, they have to first of all prove the right. They can actually do that. They can't do that. Technically, the sheriff can only seize your property. No one else can do it. You have to have a warrant to kind of do that. Usually in civil cases, if you even own a debt, you can have the bank levy the bank account. I mean the sheriff. It's different from different municipalities, but in the state of California, New York, that's how it kind of works. The debt collector can't seize your property, so if they ever sent that to you in a letter format that your property can be seized, they're not specifying who. And how the law works is that it's detailed and specific, and when they are not specifying who can do that, they're basically insinuating, basically flat out telling you that they can do it. So that's an impersonation of a government official. They call you and they have the psychological profiles of how law enforcement would act. That also would be considered a form of abuse, intimidation, or stuff like that. Deceit. Number two, restricting communication with debt calling at inconvenient times, which we discussed before. They can't do that. They cannot contact you at work. We already discussed that. If they are ignoring your requests to cease communication, like cease and desist, that's also a violation of that as well. They're restricting communication of that. If you send them a cease and desist letter, they're required to comply with it. So they can't just ignore it. If you got a second letter or another call, right? And if you have multiple debt collection agencies that are contacting you for one debt, that's another thing as well. If hired at a lawyer and the debt collector is still trying to contact you as well, and even contact you via the credit bureaus, because that's a form of indirect contact as well. So there are rules regarding that as well. They can't harass your work. They can't talk to your friends and family. They can't beat you up. They can't do any of that. So if they do any of that, that's definitely a violation. Yeah, one more thing, guys, before I end this video. So the third one is really important. The limiting of communication from debt collectors. And basically what that is, I'll give you an example. That's like when, say you're living in Texas and the collectors in Florida or California, essentially another state that is so far or inconvenient from you, as the law states, it has to be where the collector sues you in a place that's inconvenient or at a great distance, one of the two, then it will constitute as them limiting communication from debt collectors. So basically they're trying to sue you in another jurisdiction that's either inconvenient or a grave distance, like from Texas to California or Florida, it's very far. So you probably won't come to court, so they can try to bank on the fact they'll get a default in the judgment. So when a creditor does this, even if it's in another city, let's say you're in Dallas and they go to Fort Worth or maybe Corpus Christi. So let me show you how Texas, like Dallas is here, Corpus is here, okay? It's very far. The Gulf of Mexico is right there, Louisiana is here. Okay, this is the Gulf. This is very far. That's like, I think, a 3-4 hour drive. I don't know, something like that, maybe 2.5, 3, 4. and especially further down. But yeah, so that would be a situation where it's inconvenient for you to go, and you could utilize and exercise this one right here. So just understand, try to locate these debt collectors or these creditors and see where they're at, so you can, you know, use this law. And then after you basically find the violations in the FDCPA, you can get all that up, and then you could seek damages for the violations underneath the Fair Debt Collections Practice Act, and you can get some monetary relief or your items removed, or both, So there it is, guys. That's it. Thanks for watching. Stay tuned to the next one. Bye.